I'm going to look at the other side of the coin of if there is an allegation against me, or if I am accused of a crime, what are the steps available to me? Now, as someone who has been alleged to have committed a crime, my most important priority is to secure my liberty, right? So how do I do that? If I'm aware that there is an FIR registered against me for a cognizable offense. Now, under the Indian Penal Code, various offenses are categorized as either cognizable or non-cognizable. Now, cognizable offenses are more serious offenses and ones for which the police can arrest me without a warrant. So the minute an FIR is registered, if the sections there are cognizable, which means you can be arrested without a warrant, then the police can come and arrest me at any time. If the offenses are non-cognizable, then I need not worry. So if I find out that there is an FIR registered against me and the offenses are cognizable, if I want to secure my liberty, the first thing that I explore is filing for anticipatory bail, which is also known as pre-arrest bail. This is provided for under section 438 of the Criminal Procedure Code, where I approach the Sessions Court. So the powers to grant anticipatory bail are only available with the Sessions Court and higher. A magistrate court does not have the power to grant anticipatory bail. So depending on where the FIR is registered, I file for anticipatory bail in the Sessions Court having jurisdiction there. And basically I say that in my application for anticipatory bail, I would have to make out a case that though I am named as an accused for a cognizable offense, the police do not require to take me into custody for XYZ reason. Now, depending on the facts and circumstances of the case, the grounds on which I'm seeking anticipatory bail differ depending on the nuances of each case. But grounds which are common are that I am willing to cooperate with the investigating agency, that I'm not a flight risk, that prima facie I'm innocent, and that my custody is not needed. So these are the common grounds that are taken, and then there are additional grounds based on the specifics of each case. So when I file for anticipatory bail in the Sessions Court, I have to also serve a copy on the concerned police station. Then the matter is argued before the Sessions Judge, and if it's granted and anticipatory bail is allowed, then the police cannot arrest me. And if they choose to arrest me, they must grant me bail immediately on certain terms and conditions, which are normally executing a bond, providing a surety, etc. But basically, though I can be arrested, I cannot be kept in custody if I am granted anticipatory bail, because as long as I'm willing to furnish bail, they must release me. So that's my first option. Now, let's say it's very difficult to come to know when you're an accused in an FIR, unless you're anticipating it and you're keeping a track of the police station. Most often you might not know, and the next thing that happens is the police turn up at your doorstep wanting to arrest you, saying that you've been named in an FIR. Now, so let's deal with once that happens and you are arrested, what are the remedies available to you? Now, people think that when you're arrested, the most important thing is to get bail. And this is a very big misconception. The most important thing to get first is judicial custody. Now, let me explain this. How the law works is once you are arrested, within 24 hours, the police or the investigating agency that has arrested you has to produce you before a magistrate within 24 hours. Otherwise, your custody becomes illegal detention. Now, when they produce you before a magistrate, they produce what's known as a remand application, where they highlight the details of the crime and why they require your custody. Now, the advocate that is appointed by you would generally counter that to say that irrespective of this, your custody is not needed for XYZ reason. At that time, the police ask for police custody, which is your custody in the police station for them to interrogate you and investigate. Whereas your advocate asks for judicial custody, that is for you to be sent to jail and not kept with the police. Now, why does an advocate do this? An advocate does it because in law, an advocate can only file for your bail when you have been granted judicial custody. So to be clear, during the period that you are in the custody of the police, your bail application will not be entertained by the court. It is only once the court takes you from police custody into judicial custody can your bail application be heard, and do you stand a chance of being released. And hence, or at the time of your remand, the first priority for any defense lawyer is to get judicial custody. Now, how long can you remain in police custody? In most crimes, the maximum period for police custody is 14 days. Now, there are certain variations to this. For example, under the Maharashtra Control of Organized Crime Act, where this period is extended. But for our purposes, the maximum period for which you can remain in police custody is 14 days. However, the magistrate need not remand you for 14 days at a stretch. In fact, this very rarely happens. So let's say you are arrested on day 1. Within 24 hours, on day 2, you are produced before a magistrate. The prosecutor argues for you to be given in police custody, whereas your defense lawyer argues for you to be sent to judicial custody. The judge feels that there are some grounds for police custody, so he gives the prosecution 3 days police custody. After 3 days, this entire process is repeated, where the police once again produce you before the magistrate and they produce a fresh remand application showing not only the details of the crime and why they need your further custody or not, but also what they have done while you were in custody. That is also known as to show the progress in the investigation. Now, if they come back after 3 days saying that they don't want any further custody, you're automatically sent into judicial custody and your bail application can be heard. But if they say that 3 days custody has not been enough and they satisfy the magistrate that they require additional custody, then the magistrate may consider and grant additional custody. So this process can be repeated, but up to a maximum of 14 days. At the end of 14 days, you are automatically sent to judicial custody and your bail application can be argued. So depending on what the crime is, there are certain offenses which are more serious, which are triable by a sessions court, where your bail will have to be decided first by a sessions court. Most other crimes, your first bail application will lie with the magistrate. If your bail application is granted, you are released. Well and good, that's the end of it. If it's rejected, you then appeal in the sessions court, then the high court, and then the Supreme Court, provided you keep getting rejected. Now, another common question is, how many times can I apply for bail? There is no limit as to the number of bail applications that you can file. However, what the law requires is, if, for example, I have filed in the magistrate court and it has been rejected, if I choose to refile before the same court and not a superior court, I have to show a change in circumstance. So let's understand this. I file in a magistrate, it gets rejected, then I file in the sessions, rejected, high court, rejected, Supreme Court, rejected. Let's say I decide to go back to the magistrate or to go back to any of these courts. I must satisfy the judge that from the last time my bail application has been rejected, there has been a change in circumstance. If I don't manage to do that, in all likelihood, if it's the same facts and the same scenario, my application will just be rejected again. So now, what is a change in circumstance? The law has held that the filing of a charge sheet, which signifies the completion of an investigation, is a good change in circumstance for bail. There can be medical grounds, like I've developed some illness, or there can be some familial grounds, like someone in my family has expired, etc. Or there can be some new evidence that has come to light. All of this would warrant a change in circumstance. So, to be clear, there is no limit on the number of bail applications that you can file. But if you are rejected and you choose to go back to the same court, you must satisfy that court that since the last time you were rejected, something has changed, which should warrant a new decision and a fresh consideration. So these are the basics of what you can do as the victim of a crime and what you ought to do as someone alleged of a crime. So I tried to be as concise as I could and give you as much information. Of course, you'll learn a lot more along the way. So yeah, I hope you enjoyed this class, and hopefully Her Forum will give me the opportunity to have more such discussions with you. So thanks.